In this video, I'm going to share with all you young medical malpractice lawyers some tips about opening statements, and honestly, I don't think you've heard these tips before. My name is Frank Spector. I'm a medical malpractice lawyer in Maryland and in D.C. I've been doing this for over 33 years, and during that time, I've had the privilege of representing thousands of people, getting them the justice and compensation they deserve. I was an adjunct professor at my law school, and I've tried many medical malpractice cases. When we stand up for opening statements, I want you to throw this idea in the garbage can, the idea that you're an entertainer. When we stand up to address jurors at opening statement, we're not comedians, we're not singers, we're not there to put on a show. What are we supposed to do? We need to establish ourselves as someone who has trust and authority. Jurors already have a negative impression of lawyers, so if you do things that feed into what they already think about you, that's not going to be good for you and your credibility. Another thing, they probably have never served on a jury before, and if they have been on a jury, it's likely they have never served on a medical malpractice case before. They don't know what's going on, they're not familiar with the terminology, it's all new to them. And they're looking for someone that they can trust. The truth is they already trust the judge because he's the authority figure or she's the authority figure in the courtroom. But you need to establish trust and authority for yourself and develop that relationship with the jury. Honestly, medical malpractice cases can go many weeks, but that relationship has to be built over time. They need to trust you. So how do they do that? The first thing is don't stand up and be an entertainer or a comedian. That's number one. Be professional and address them in a professional way. Number two, show them very methodically how you're going to prove this case. Establish with them what the elements of a case are and what you intend to prove at trial. Bring them facts. Show them documents. It's your opportunity to begin to establish that relationship with them, because when you do, as the case goes on, they're going to look to you because they already believe that you're somebody who can be trusted. Never lie to them. Never tell them that you can prove something that you can't prove. Never try to pull the wool over their eyes because they will sense that right away. And if they find that you're not dealing with them honestly, they will hold it against you and your client. Tell them exactly how the case is going to go. Explain to them how witnesses are going to testify. Give them the information that they need, because once they hear it from you, and if you're the plaintiff's attorney, you have an opportunity to speak to them first. So you can establish trust and authority by walking them through the process, because once they see how that process plays out, they'll say, that's just exactly how this lawyer told me it was going to be. They're going to trust you. Now, as the case wears on, day after day after day, make sure that in opening statement, when you said you're going to prove something, that you prove it. Make sure that when you say you're going to show them something, a document or medical record to prove what you've said in opening statement, make sure that you show them that. And then I'm going to have some tips for you about how you can wrap all this up in closing arguments so that the trust that you have built up with them can culminate in a victory for you and your client.